every good malpractice lawyer has to take his or her lumps. We all lose cases at trial. We have to have the courage to take on difficult cases, as Paul did here. And we have to demonstrate, I think, to the defense that we're prepared to take on the difficult case. So, Paul, well done. I'm going to talk about winning your case at discovery. And I think it's an important subject. You know, I'm going to borrow a line from Bernie Gluckstein about risky business. But so Bernie talked about making risky business less risky. I thought that was brilliant, by the way, Bernie. And that's what winning your case at discovery is. It's about making risky business less risky. So I think that if you conduct the discovery, and for those of you who don't know what a discovery is, in the middle of a lawsuit, you get to examine the opposite parties about all the issues in the case. And why do you want to win your case at discovery? Well, it's all about mitigating the risk. More difficult question is, how do you win your case at discovery? And we're going to come to that. It also saves expense. If you can establish that you have a very good case at discovery through lots of admissions from the other side, then it's going to save everybody all kinds of expense, I think, which is very important because there is going to be an incentive to resolve the case earlier. Also, if you've done a good discovery, you're going to get the best possible result for your client, which is always number one, right? Always get the best result for your client. You get settlement earlier, and guess what? You're going to get paid. So that's important. So the thing I like to talk about in these discoveries that makes them different from discoveries in other kinds of cases is that the defendants are all experts in medical malpractice cases. I'm examining an obstetrician, I'm examining a nurse, they're experts. And that could be very intimidating for you as a lawyer to face an expert and have as your goal the objective of extracting admissions from those experts that are going to prove your case. Lofty goal. So in order to do that, I think somebody spoke about this already today, is you must know their field of expertise before you go to the discovery. In obstetrics, as an example, just because I do a lot of obstetrics, in addition to the education that I've had from Dr. Schifrin, I do a lot of research, a lot of careful research before I get there on the specific issue that I'm going to be examining the physician or the nurse about. I know all the guidelines. I'm current on all the medical literature because I'm not going to get these experts to say things that sink their case and help my case unless I speak their language. Got to speak their language. So their language is complex. It involves complex matters of science. Dr. Schiffer talked to us about some of it today. So you have to you need to understand how your client got from an uninjured state to an injured state. You need to know how that happens. I need to know the things you have to do to prevent that from happening. That's how you ask their question. Speak their language. The other thing you have to know is, I don't know if I should say, bullshit baffles brains. I'm going to say it anyway, right? Okay. Experts, particularly some of the more arrogant experts, are going to try to pull the wool over your eyes. They're going to start to use medical jargon that is not familiar or they think you don't know about. They're going to try to tell you things that aren't so. And you need to put them in their place, but you can't unless you know the science. Often, I'm going to give you, by the way, examples of all of this. Sometimes they're not responsive to your question. You got to stick with it. You got to get the answer. And sometimes they're plainly wrong. And you have to be able to confront them on those things. The other thing is that the lawyers who represent doctors and hospitals are very experienced, talented counsel. Some lawyers on the plaintiff side will say that, well, the reason that malpractice cases are so difficult is because the CMPA and HEROC have this scorched earth defense policy. They defend these cases so vigorously that it makes it impossible to succeed in a malpractice claim. I disagree. I think that the CMPA and HEROC do a good job for their clients. I think that the doctors are entitled to a defense where there's a defense to be had. I think it's our role on the plaintiff side to make sure that we overcome that defense. And we can only overcome that defense if we're really good at what we do and we really prepare. So we have to know the records. You have to know what's in the records. More importantly, you have to know what's missing from the records. And you can't know what's missing from the records unless you know what is supposed to be in the records. And you can't know what's supposed to be in the records unless you've done your homework. So I'm going to give you some examples. And these are real cases. These aren't the examples yet, but I'm going to talk about some real examples of discovery questions asked by lawyers who would tell you that they were experienced malpractice lawyers. And I'm going to demonstrate some of the mistakes that they made in examining the defendant. So before you go to examine somebody, you want to know the areas. I call them the headlines. You want to know the areas that you absolutely must cover with the expert. You have to know the things that can't be missed. And then I like to say you establish the rules early. So we start by saying, are we agreed on what the medical terms are? In an asphyxia case, are we agreed with how you establish a baseline? Do we know what a normal baseline is? What's a deceleration? What are the clinical things that lead to that? Let's establish the rules ahead of time so that when you come to examine the facts of the case, the expert can't depart from the rules. We've established the rules. Very important. Definitions of medical terms, get those established early as well. Understand what their training is. And then I like to say, you may be inclined to have detailed notes before you do a discovery, but don't. You're not going to, you have to listen to the answers. When you get the answer, you have to make sure you follow up on the answers that you get. And if you have a script, then you'll stick to the script and you'll miss very important stuff. Because answers that the witness give will always lead to other questions. And you must exhaust each area of questioning before you move on to the next one. So if the witness comes up with something that takes you off on a tangent, take that tangent with the witness and circle back later on when it's appropriate. Otherwise, you're going to forget it. So double back. And I just make point form notes. I don't take notes when I'm examining one of these witnesses. I take point form notes, only highlighting the things that I need to come back to in the event that it's necessary. And then I'm also thinking, remember that when we do discoveries, we get a transcript of the evidence. And I'm always thinking about how that transcript is going to read. So I ask short questions, concise questions. I try not to start each question with okay. And I avoid I'm always thinking about how does that transcript read? I use an economy of words in each question so that I know that what I get out of it is going to be useful to me later on if I need it. Very important. So how does a transcript look? Only one person talks at a time. That's a big problem because everything is being recorded. And I like questions to be short and concise. If they're not, then they're not going to be of any value to you later on. So be very precise in the formulation of each question. And then some people think that you need to use leading questions all the time, questions that suggest the answer. I'm very happy to use open-ended questions at examinations for discovery. Let the witness talk. The witness may want to say stuff that they think is helpful to their case. Inevitably, they put their foot in it. Okay, so let them talk and just watch for it. It's going to happen. Every time it happens. Okay. This is a big problem in discoveries in medical malpractice cases. The defense objects a lot, and it can really throw you off your game. So you got to be able to deal with objections. Don't let it throw you off your game. If you ask a question that is appropriate, you'll always find another way to come back to it. Ask the appropriate question. I'm going to give an example of this, how you come back and ask the appropriate question. Don't get into an argument. If the other lawyer wants to talk on and say, tell me what state your objection, and then don't say anything else. You're not the witness. If you object to the question, that's fine, but don't start giving evidence. So I'm going to give you an example of that too. Because if they're going on and on after you ask a question that they find objectionable, what they're doing is indirectly coaching their witness. That's what's happening. They're giving them the answer, and you don't want that to happen. So when you get an objection, think about rephrasing the question in a way that is not objectionable, or come back to it later on. So some examples. Here's an example. Question: other than what's recorded in the chart, do you have any independent recall of your interaction with the plaintiff? Now, there's nothing wrong with the question. What's wrong is the defense lawyer pipes in and says, that's lawyer speak for do you remember her? Well, that's not what the question is, but this is a warning. Okay, this is how undue interference by the other lawyer starts. Please do not restate my question. If you find it objectionable, say so. Otherwise, let the witness answer the question. That's not what I meant. So be cautious about that. The other lawyer is going to interject. Yeah, I often say to the witness, or if you do not understand my question, I would be happy to restate it. Another example. When doctors write they assess the patient walking, is that also reference to assessing her gait? Answer refused. Question, or defense lawyer, you can ask him if he assessed her, that should be gait, her gait, or if that's what he meant, if you want. So it's a terrible question by the lawyer. It's a question that the lawyer hasn't thought about. When doctors write. This case isn't concerned about when doctors write. This case is concerned about what you wrote, doctor, not when doctors write. We don't care what the meaning is with other people. This is what I mean by thinking carefully about your question and formulating your question in a way that will not attract objections, but also means what you intend it to mean. Don't ask the question this way. You need to think about your questions. Objections interrupt your flow. You're going to get flustered. And on this discovery, it happened dozens of times. And the lawyer never got anything half decent out of the witness. In the absence of osteomyelitis, was it your view that an X-ray would be of help in determining whether or not she had an epidural abscess in the spine? Answer, I think an X-ray is a cursory test. I think all tests are helpful in some ways. Question, did you think it was the appropriate diagnostic imaging to determine whether she had an epidural abscess? Refused. Why? Did you think it was the appropriate? That's the offending part of that question. The defense lawyer is going to say, this witness is not here to give standard of care evidence. And they're not here to give standard of care evidence. So how can you extract standard of care evidence out of this witness? And the answer is this. Was epidural abscess on your differential diagnosis at the time? Now we're focusing on what this doctor was doing at the time. Had you ever treated a patient with an epidural abscess before? No objection. What diagnostic tools were available to you to rule out or in an abscess? Well, that's getting at the test, that the refusal. What did you understand to be the gold standard for ruling that diagnosis in or out? What did you understand to be the risks of epidural abscess for the patient if untreated? Why did you think you could rule out epidural abscess without X test, whatever the test is? All legitimate questions, all highly focused, all questions that will extract a standard of care opinion out of this witness without asking for a standard of care opinion. This is what we have to do. And these are admissions that we need to win the case. So in this case, this answer was refused and the lawyer moved on to the next subject. Bad idea. This lawyer did not win the case at discovery. Why? Because the lawyer did not ask the right focus questions. These questions are dynamite. The ones that I put down, you're going to get everything you need to shut this case down in a hurry, right? I hope you see the difference. It's an important distinction. Would you agree with me that in these circumstances, the fourth time to the emergency department, it would have been the standard of practice at that time to call for the charts to be made available to you? Refused. Why? Standard of practice again. And so eliminate standard of practice from your vocabulary. It should never be part of your vocabulary. How do you ask this question? How do you get the answers that you want? Framing the question as standard practice invites an objection. What was the clinical significance to you of a patient returning for the fourth time? What consideration did you give to the failure of the first three visits to resolve her problem? Was it your impression, given the lack of improvement, that she may be presented with a condition not diagnosed on the previous three visits? Did you consider the diagnosis offered on the first three visits? Did you expand your differential diagnosis? What did you include? What steps did you take to rule things in and out? Why did you do it? And why did you do something else? Everything that you need to capture the admissions that you require. And all of these answers, by the way, questions require straightforward answers. And if there's any embellishment, you'll follow up on the embellishment. If there's any failure to answer the questions, you will repeat these questions because these questions allow only for one answer. That's how you win at discovery. Another example, would you agree with me that proper neurological examination of a patient in pain requires a history? The same flaw. Did you conclude that this patient had a neurological problem? It's the proper question. Did you perform a neurological examination? That's the proper question. What were the components of your neurological examination? Highly focused. What were your findings? Did you examine whatever? Why didn't you do the missing test? What is your understanding that the missing test might help, or was it your understanding the missing test might help? But all unobjectionable questions, but all getting to the point in a very focused and concise way. So this is an obstetrical case where opportunities were terribly botched. And how much of the fetal heart monitoring did you review at the time of this initial assessment? Answer, I reviewed usually about half an hour to 1 hour length of tracing. Question, what did the tracing show? Answer, it was normal. Question, for what period? Answer, it was normal. Question, and is it still your opinion that this tracing was normal? Refused, not relevant. Who cares whether it's still the opinion that it wasn't normal? Why invite this objection? Why ask the question that way? There's no reason to. It's going to interrupt your flow. The questions must focus on what occurred at the time. Question, and when you assess these strips, when you look at these strips, what are you looking at for, doctor? You look at the baseline, you look at the baseline variability, you look for accelerations and or decelerations. Answer, okay. Answer, you look at the number of contractions in 10 minutes. Well, these are simply not the right questions. What this question tells me is that this lawyer is unprepared to do the examination. What it tells me is that the lawyer does not have an understanding of the medicine. What it tells me is that the lawyer is unable to speak the language of the witness. And if you can't speak the language of the witness, you can't get the answers that you need. So you have to start with the rules for assessing the fetal heart rate. What do we mean by baseline? You have to know the answer as the lawyer. What do we mean by variability? What do we mean by decels and accels? And what are you talking about when you say the number of contractions in 10 minutes? Right, there's way more features of the fetal heart rate, and there's way more features of uterine activity than are described in this question that were critical to this case, which the lawyer did not understand, and therefore an opportunity to get the admissions that he required in order to win the case was squandered. You're not only looking at the number of contractions in 10 minutes, it betrays a lack of knowledge on the part of the lawyer. So it's the preparation that we do ahead of time and how we phrase these questions that is the important thing. Another example. And did that normal baseline variability continue through the time period that you reviewed? Answer, yes. All the way to 2015, more or less, yes. More or less. What does that mean? It's so imprecise. It's completely useless. You have to ask the witness, what do you mean by more or less? And then you have to take the witness to the tracing and show me where it's more, and explain why you thought it was more, and show me where it's less, and tell me why you thought it was less, and then tell me the clinical significance of both for the well-being of that baby. Based on that more or less, did you think this baby was well oxygenated? Do you think that it was safe to manage this labor expectantly? Did you realize that the fetal reserves may be diminished? I mean, what's the basis for you saying that? But you can't ask what the basis is for saying it of a witness unless you know the answers to expect and how to follow up on the answers. So this was a crucial issue in the case and an opportunity squandered to get what was needed. So you got to listen to the answer. Where the answer is imprecise, you got to follow up on the answer, and you have to know how to follow up on the answer. And you want to know why. You came to a conclusion, explain why. What was I often say to these witnesses, what was the clinical evidence that supported your decision to do X? Tell me all the clinical evidence that supported your decision to do X, and they will break down each one. Question, and if I understood your evidence correctly, you were looking at the number of contractions within a 10-minute period. Yes. Why do you do that? Answer, because you need to see whether you're having the frequency of contractions that may affect cervical dilatation, effacement, and descent of the presenting part to consider one, that the woman is in labor and that there was a progress of labor. Question, anything else? Answer, that's about it. So this is an example of bullshit baffles brains. Okay. This is telling the lawyer gobbledygook about the tracing that has no meaning for the purposes of this transcript. And what you must not do in these situations is you must challenge the expert directly on what he's saying or she's saying. Can't accept this stuff. The lawyer had no idea how to deal with this, moved on to the next question. You must dissect this to its underlying foundational components until you've exhausted the issue. And when you do that, you're going to get admissions from the doctor and from the nurse that kill their case and make your case. You are, but you have to have the knowledge to do it, and you have to know how to frame the questions, and you cannot be bamboozled. So I had a case once, an obstetrical case, where I took the doctor to the tracing, and he gives me an interpretation of the tracing, and I said to him, doctor, what's the basis for you telling me that this tracing means what you say it means? And he says to me, well, our professional guidelines tell us that that's the case. I said, well, what professional guidelines are you talking about? He said, well, I'm a member of the Society of Obstetricians and Gynecologists of Canada, and they produce guidelines periodically on fetal surveillance, and that's what told me what to do. Very interesting, doctor. What guideline are you referring to? I said, well, it was published in 2007. Oh, I reach into my briefcase and I pull out the guideline. It's about 60 pages long, and I throw it across the table. I say, we're going to adjourn for half an hour. I'm going to let you read the guideline, and we come back in half an hour. You're going to point to that guideline to where it said what you just testified to under oath. Okay, half an hour. Take your time, read the entire guideline. So we go, we break half an hour, we come back, he sits down, he looks at me, we're back on the record, he says nothing. Doctor, isn't it true that there is nothing in that guideline that supports the evidence you gave me under oath? Yes, that's right. Doctor, isn't it true that the guideline in fact contradicts the evidence you gave me under oath? That's true. Why? I know the guideline like the back of my hand. I've read it 1,000 times. Right? So there were 5 more witnesses to be examined in this case. We canceled them all. Case was over. Just because he lied about the guideline. So this is what I mean by you got to know their field, and you got to know when they're pulling the wool over your eyes. Question, okay, I take it you don't dispute that you were contacted by the nurse at about 2050. Answer, I don't. Question, it appears from the records that you were in at about 2130. Answer, yes. Did you review the monitoring strip? Answer, yes. And I wrote it was reactive. Answer, when you say it was reactive, what do you mean? Answer, reactive means the variabilities within the womb, there were accelerations. Okay, so just that it's clear, you're saying that there is acceleration shown on panel, blah, blah, blah. Answer, yes. Well, what does that even mean within the womb? There's variabilities within the womb. It's not even an expression that doctors use, but you need to know that. And variability and accelerations are 2 different things. And reactivity is something that is a term that they generally don't use to describe EFM patterns in labor. And you just have to know all of these things. You just have to know them. And when you challenge them on, what happens is then the witness becomes less and less secure as your questioning goes on. And you find that when you continue to challenge them and expose the flaws in their evidence, later on in their testimony, you find you're getting more and more admissions as time goes on, right? They sort of, right, Brian? Didn't we see that last week, right? So we were examining a nurse last week, and this is how we went through it. And as it went on, the admissions were flooding. By the end of the discovery, she admitted everything. Why? Because I had challenged her on her errors. And eventually she had to admit her errors. First, I proved the rules. Then I established that she had made errors in the chart based on her own nursing rules. And then when we finished examining the tracing, she admitted to all kinds of breaches of the standard of care at discovery. I mean, it's a big difference. So watch out for this gibberish that you get from witnesses. Take the witness to the strip and get them to identify very specifically the things that you're talking about. So here's a strip. This is, I mean, what I do sometimes in these cases, although this is an old case, it's all, you know, as Dr. Schifrin said, these are the contractions, and this is 1 minute from here to here. And I count the number of seconds of each contraction, and I write it down just to remember, so I'll remember, because I have this in front of me, and I'll remember the number, and I'll go to the nurse and I'll say, take a pen and write a vertical line where you see this contraction starting, and write a vertical line where you see this contraction ending, and then count the number of seconds for me. She's going to say it's 100. Actually, she doesn't. She's going to say it's 80, even though it's 100. Okay, she'll say it's 80. I'll say, okay, write 80 here. I don't mind that she writes 80 when it's 100 because I'll prove it wrong at trial. So that's really good, right? And then I'll say, well, in the chart, what did you write here? 40 to 50. Can you help me to understand why there's a contraction that's 80 to 100 seconds long, but you wrote in the chart that it's 40 to 50? Help me to understand why that happened. Oh, I must have made a mistake. But I'll prove that mistake 1,000 times throughout the course of the tracing. And eventually, she's going to capitulate. So she gets that right. Now, your nursing colleague that relieved you from looking after this patient, how was she supposed to know what happened if the contractions are 100, but you're only recording 40 to 50? Who did you think was relying on this record? Did you think anybody was relying on this record? In what way were they relying on this record? So, and I'll do that with everything. I'll question everything so this is what the nurse said in the chart on page 15 at 2130. These are the things she said: fetal heart rate, variability, accelerations, decelerations, contractions. By the way, contractions too close together, 1.5 to 2. And so this allows me to, with this note, I don't have to rely on any handwritten notes. I can just go right to this tracing. Now I do it in this is a very old one. I do it in a much more sophisticated way now. But I'm running out of time. So this is just another example of a nonsense answer. Okay, so again, the tracing here, we see some decelerations, which I've circled. We see long contractions, close together, short rest time. We have to know, what those decelerations are and what they mean. And I've got notes about what I'm going to ask the witness about. I'm going to leave a couple of minutes for questions because these are just more examples of just lawyer not being prepared. So why do we want to do good discoveries? Is because we want to win our cases. We want to get admissions from the other side that make sure we win our case. If after a discovery you feel that you don't have sufficient admissions to win your case, then you have to reconsider whether the case has merit. Maybe you've taken on a case that really isn't worth pursuing. Maybe you should drop the case. Not all these cases succeed. So you may not have evaluated the case properly from the get-go, even if you have an opinion. If you don't get admissions that help your case, even if you have an expert opinion, your expert opinion might be wrong. You need to reassess whether this is a case you want to continue with or not. And in obstetrics in particular, by the time you get to trial, your disbursements are $300,000 or $400,000. So you better make sure that you've done your homework, and that's why you want to win your case at discovery. Anybody have any questions? Yeah.
Just talking about the admissions and how you know this. For younger lawyers who may not know this, as they rely on their experts after you give them the transcript and then get a report that shows that doctor was incredible. If you're in that position, how do you use that report to then win your case?
A later report?
Yeah, you missed the opportunity of discovery, but you got the transcript going to the expert. You're still able to show that that gibberish was, you know, typical wild.
Well, it's much more challenging because you don't have admission. So what do we do with discovery? When you do discovery, you get a transcript of the questions and the answers. And ideally, you want to be able to read those questions and answers in, the admissions in, to a judge to demonstrate that they've given answers that are against their interests. If you have to rely on an expert to interpret the discovery, I think you've just lost an opportunity. The other thing is not all experts are as reliable as we'd like them to be. They make a lot of mistakes. It's up to us as advocates to make sure that we do a complete job on these cases, that we understand the medicine, that we get the admissions. And in fact, it helps with your expert, because if you get a good transcript where you have admissions from the expert, from the defendant, and then you send it to the expert, it just solidifies the, and whatever I said in my earlier report, 10 times that. It's even worse than I thought, right? Based on the transcript. So your case just improves. After good discovery, your expert opinions improve, your case improves. The other side will want to settle earlier. And as I said, if you didn't get the admissions, reconsider whether or not your case has merit. Anybody else? Okay, thanks.
Thank you.